All right, let's dive into UK contract law. You sent over some excerpts from an introductory document, and, well, contract law might not sound super exciting, but trust me, there's more to it than meets the eye.
Definitely. It's really the backbone of so much in our lives, wouldn't you say?
Yeah. Like, think about it. Buying a coffee, landing a job, even streaming shows, it's all based on agreements, right?
Exactly. And those agreements are shaped by, you guessed it, contract law.
Okay, so your source material lays out these five key elements of a contract: offer, acceptance, consideration, intention to be legally bound, and capacity. Where do we even begin?
Well, those are like your essential ingredients for a legally enforceable agreement. Miss one, and you might just have a friendly promise, not something a court would recognize?
Gotcha. So, first up, offer. I'm picturing like a dramatic courtroom scene, someone yelling, I offer you $1 million. Does it have to be that intense?
Haha, not quite. An offer can be way simpler, like a statement or even an action showing you're ready to make a deal. The key is, would a reasonable person think you're serious?
Okay, so what about those buy one, get one free signs everywhere? Is that an offer I can just grab right away?
That's a good question. That brings up the whole offer versus invitation to treat thing. Most ads, like those signs, are actually just invitations for you to make an offer. They're basically saying, hey, we have these goods. What'll you give us?
Oh, so just browsing online or filling my basket isn't actually a done deal.
Exactly. More like window shopping. You're interested, but not locked in until you hit that confirm order button and go through checkout. That's when you make the offer.
That makes a lot more sense. But your source material mentioned this case, Carlill v. Carbolic Smoke Ball Company. They marketed this smoke ball as a flu cure, even set money aside to prove they meant it. But when someone actually got sick, they tried to say the ad wasn't a real offer.
Yeah, that's a classic. Shows how an ad can become a real offer. The court basically said, nope, their words and actions, especially that money thing, showed they were serious.
Wow, so companies had to watch out for their marketing even back then. That actually brings us to the next element, right? Acceptance. Does it have to be as dramatic as making the offer?
Not at all. But here's the thing. It has to be a clear yes to everything in the offer. Any changes, even small ones, turn it into a counteroffer, and that resets things. The original offer's gone.
Wait, so if I say I'll buy your car for 5,000, but can you include new tires? Is that a deal breaker?
Yep, that's a counteroffer. You change the terms, so now you're making a new offer. The seller can accept, reject, or counterback. The first offer's off the table.
Okay, got to be careful with those add-ons then. What about those I agree to the terms and conditions boxes online? Do I really have to read all that fine print?
I think we've all wondered that. Legally, clicking that box usually means you accept, even if you didn't read every word. It goes back to that reasonable person idea. The court would likely say, a reasonable person knows that click means they agree to the terms, whether they read them all or not.
Okay, makes sense, even if it's a little scary. But let's move on to consideration. That word makes me think of, like, Jane Austen novels and fancy dinners. Is it really that formal?
Uh-huh. It's not quite Jane Austen, but consideration is definitely important. Basically, it means something of value has to be exchanged for the contract to be, well, enforceable. Could be money, goods, services, even agreeing not to do something.
So, like, if I promise to stop playing loud music after 10 p.m. and my neighbor promises to bake me cookies every week in return, could that be a contract? Cookies for peace and quiet, huh?
You're getting it. It's about the mutual agreement to exchange something of value. The courts don't really care if you got a good deal or not.
That makes me think of those stories about musicians selling their song rights for, like, nothing. Then the song becomes a huge hit. Are those contracts still valid, even if they seem totally unfair now?
That's a really interesting point. It comes down to this idea that consideration has to be sufficient, but not necessarily adequate. So there needs to be something of value, but the court won't usually say if it was a fair market price or not, unless there's something fishy going on, like fraud or pressure.
So even a single peppercorn, like in that famous example, could actually be enough to make a contract official. That's wild.
It does sound strange, but there's a reason for that. Courts generally want people to be free to make their own agreements, good or bad. If they started judging every deal, it would just cause chaos.
Okay, so consideration adds that layer of seriousness. It's not just casual promises anymore. But what about intent? I can't be legally bound by every little thing I say, right?
Right, and that's where intention to be legally bound comes in. Another key ingredient. Think about everyday stuff, promising to meet a friend, promising to do the dishes. Not contracts, right?
Definitely not, or we'd all be in trouble.
Exactly. In those everyday situations, nobody assumes you're making a legal deal. But when it comes to business, it's usually the opposite. The courts will assume that people doing business did mean to make a legally binding contract.
So if I jokingly offer to sell my old record collection to a friend for $5 over a beer, I could actually end up in court.
Well, while a pub chat might suggest otherwise, it's always a good idea to be careful about what you say, especially when money or valuable stuff is involved. If your friend takes you seriously and things go south, you might have a hard time proving you weren't actually making a deal.
Yikes, noted. This makes me wonder, how much do you actually need to say in a contract? Can you leave things out?
That's a great question, and it brings us to implied terms. These are things that aren't directly stated in the contract, but are so basic to the agreement that a court would just assume they were meant to be there.
So, like, if I hire a plumber to fix a leaky faucet, it's implied that they actually know how to do plumbing, even if the contract doesn't specifically say must have plumbing skills.
Exactly. There's that general expectation that professionals will know what they're doing. It's an implied term, even if it's not written down. Same with buying something from a shop. It's implied the goods will be decent quality.
So even a simple contract can have all these hidden layers of meaning, like an iceberg. Speaking of hidden things, what about this objective test your source mentioned? What's that all about?
Ah, the objective test, a cornerstone of contract law. It means the courts will look at what a reasonable person would understand from your words and actions, not what you secretly meant.
So if I'm mumbling and someone mishears me, I'm stuck with whatever they thought I said. Seems a little rough.
Might seem that way, but that's why it's so important to be clear in any agreement. The objective test is all about making sure your words and actions match up. Otherwise, you could end up in a contract you didn't even mean to make.
Okay, good to know. What happens if I get it all wrong? Like, I accidentally agree to sell my house for way less than it's worth.
That's when things can get tricky. Courts don't usually let people back out just because they changed their mind or made a bad deal. But there are some very specific situations where a contract can be thrown out because of a mistake.
So, there's a chance I could be saved from my own stupidity.
It's possible, but it's a long shot. You'd have to prove the mistake was so big, so fundamental, that it messed up the whole agreement. Like, if you agreed to buy a painting thinking it was an original, but it turns out to be a fake, then maybe the contract could be canceled.
Okay, so there's hope. This brings up another question. What about contracts made under pressure? If someone forces me to sign something.
That's a really important point, and it brings us to duress and undue influence. These are legal ideas that protect people from being forced into contracts. Duress is usually about threats, like physical harm or doing something illegal. Undue influence is more subtle, more about abusing a relationship of trust.
So if someone threatens to spill my deepest secret unless I sign, that would be duress.
Exactly. If you can prove you were threatened into signing, the courts can throw the contract out.
And what about undue influence? Like, what kind of situation would that cover?
Imagine, say, an elderly person being pressured by their caregiver to sign over all their assets. That could be undue influence, where the caregiver takes advantage of their position to get something they shouldn't.
Wow, so it's not just about the words on the paper, it's about how you got there in the first place.
Exactly. Contracts should be made freely and fairly. If someone is forced or tricked, it just doesn't work.
This is all making me realize that contract law is way more than I thought. Not just signing a piece of paper. It's about knowing your rights, protecting yourself, making sure the agreements are real and fair.
Couldn't have said it better myself. It's about making sure those agreements reflect what everyone really wants and that nobody is getting taken advantage of.
Now, I'm curious about this capacity thing from the source material. What does it mean for someone to even be allowed to make a contract?
Capacity basically means whether someone is legally able to make a binding agreement. The law recognizes that some people might not fully understand what they're getting into, like minors, people with mental impairments, or those under the influence of drugs or alcohol. They might not have the capacity to contract.
So if someone's clearly drunk when they sign a contract, it won't hold up in court.
Probably not. The court would look at whether the person was so intoxicated that they couldn't understand the agreement. If so, the contract could be voided.
This all makes me wonder, how do courts actually figure out what a contract means? Do they just read the words, or is there more to it?
It's more than just reading the words. There's a whole process of interpretation. Courts look at the plain language of the contract first, what the words actually say.
So like a dictionary definition kind of thing.
Kind of, but it goes beyond that. They also consider the context, the purpose of the contract, what the parties were trying to achieve, the whole picture.
So it's not just about being a grammar expert, it's about understanding the intention behind the agreement.
Exactly. And sometimes there are these things called ambiguities where the language isn't clear, could be interpreted in different ways.
Uh-oh, sounds like a recipe for a dispute.
It can be. If there's an ambiguity, the court might look at things like previous dealings between the parties, industry practices, even common sense to figure out what they meant.
So contract law is like a detective novel. You have to piece together all the clues to solve the mystery.
I like that analogy.
So
And speaking of solving mysteries, let's talk about what happens after a contract is formed. Is it just smooth sailing from there?
well, I'd like to think so, but I have a feeling it's not always that easy.
You're right, it's not. Even if the contract is perfectly valid, things can go wrong. Circumstances change, people mess up. Life happens. That's where we get into breach of contract.
Okay, so let's say I hire a band to play at a party, but their van breaks down and they can't make it. Is that a breach of contract?
Could be. A breach is basically when someone doesn't do what they promised in the contract. But it's important to remember, not all breaches are the same.
So there are different levels of badness when it comes to breaking a contract.
Absolutely. You have minor breaches, like a small delay in delivery, and then you have material breaches where a key part of the agreement is broken. The consequences depend on how serious the breach is and what the contract actually says.
So in my band example, could I demand a full refund even if they had a good reason for not showing up?
It all comes down to the terms of your contract. Some contracts have what's called a force majeure clause, which basically says, hey, if something crazy happens that's outside our control, like a natural disaster or, a broken down van, then we're not liable.
So if they had that clause, they might be off the hook. What if there's no such clause and one party is clearly in the wrong? Do we all just lawyer up and go to court?
Well, litigation is always an option, but it's usually the last resort. There are other ways to handle these things, like negotiation, mediation, even arbitration. Those can be cheaper and less stressful, and they might even help save the business relationship.
So it's not always about fighting it out in court. There are other ways to find a solution.
Exactly. Most people just want to fix the problem, or, if that's not possible, cut their losses. Going to court can be a huge headache, and there's no guarantee you'll win.
Makes sense. Seems like avoiding breaches altogether is the best strategy. But how do contracts actually end, assuming everyone does what they're supposed to?
The simplest way is by performance, meaning everyone fulfilled their obligations, did what they promised. Once that's done, the contract naturally ends.
So if I hire someone to build a website and they deliver it on time and it meets all the requirements, we're done, no more contract.
Exactly. Another way is by agreement. This means both parties decide to end the contract, even if it's not finished.
Okay, what if I hire a contractor to remodel my kitchen, but halfway through I realize it's way too expensive? Could we just agree to stop, even though the kitchen's only half done?
As long as both sides agree, and there's a clear plan for what to do about unfinished work and payments, yeah, you can end a contract early.
That's good to know. There's some flexibility there. Seems like UK contract law tries to find that balance between protecting people's rights and being practical.
You got it. It's a fascinating mix of established rules and adapting to the real world.
Well, I'd say this deep dive has been a real eye-opener. We started with what seems like simple ideas, offer, acceptance, consideration, but wow, there's so much more to it.
It's amazing how much complexity is hidden beneath the surface, isn't it?
We've learned about being clear in our communication, the surprising power of a peppercorn, the importance of those unspoken terms, even the dangers of casual chats at the pub. Who knew contract law could be so interesting?
It's been a pleasure exploring all of this with you. Hopefully our listeners have a better grasp on these agreements that shape our lives.
I think it's safe to say we've all learned a lot from this deep dive into UK contract law. Thanks for joining us, and remember, whether you're striking a business deal or finding a lost dog, a little legal knowledge goes a long way.